This case is set for a plea today. The court understands, based upon the paperwork presented to it by the attorneys, that the defendant is going to plead guilty to aggravated assault, count 5, assault by strangulation, count 6, and then would be pleading to an added count 7 of home invasion in the 2nd degree, which means count 1, home invasion 1st degree, will be dismissed. Counts 2 and 3, which are both assault, resist, obstruct a police officer, will be dismissed. And count 4, of simple assault and battery, will be dismissed. Mr. Carnes, is that a correct statement of the pretrial agreement?
Yes.
Parties? Thank you. And Ms. Firavento, is that a complete and accurate statement of the agreement?
Yes, Your Honor, and I reviewed that agreement several times with my client. We also filed with court this morning the felony advice rights form.
All right, thank you very much. All right, Mr. Oswald, have you heard what the attorneys and I have just discussed?
Yes,
Is that how you wish to resolve the case today, sir?
yes, sir.
All right, thank you. One moment. Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may lower your hands. All right, Mr. Oswald, looking back on February 21st of this year, 2026, were you on probation anywhere?
No, sir.
Were you on parole anywhere?
No, sir.
And were you on bond pending any felony charges anywhere?
No, sir.
All right, so you are currently charged on a felony information, which is just simply a piece of paper, and you're charged on it with 6 counts. Count 1 is a charge of home invasion in the 1st degree. Now that's a felony punishable by up to 20 years and or up to $5,000. Now there can also be what's called consecutive sentencing, potentially imposed for any other conviction arising out of the same transaction. Consecutive sentencing means, let's say a person is charged and convicted with 5 counts, and the judge gives them 5 years for each one of those. Consecutive means, well, you serve 1, then you serve the next, then serve, so you end up serving 5. Does that make sense? Concurrent sentencing means no matter what, they're all served at the same time. So the day into confinement is a day off of each one of those sentences. So count 1, the felony home invasion 1st degree, will be dismissed. Counts 2 and 3 are both the same type of charge involving 2 different officers. They are both a charge of assault, resist, or obstruct a police officer. Those are felonies punishable by up to 2 years and or up to $2,000. However, those counts will be dismissed. Count 4 is a charge of assault or assault and battery. Now that's a misdemeanor punishable by up to 93 days and or up to $500. And there could be consecutive sentencing if that assault occurred within a confinement facility, such as a jail. But I'm going to guess from the name of the individual that that's not what occurred, but it also really isn't necessary to talk about because that charge is going to be dismissed. So now we're going to come up to the 3 charges for which you are going to plead guilty from what I've told. 5 is currently listed as a charge of aggravated assault. That's a misdemeanor punishable by up to 1 year and or up to $1,000. Count 6 is a charge of assault with intent to do great bodily harm less than murder or under the theory of strangulation. I'm told that here the assertion is one of strangulation. That is a felony punishable by up to 10 years and or up to $5,000. And I'm going to assume, based upon the name of the individual, that that did not occur in a place of confinement. Therefore, there's no consecutive sentencing. So far, you're pleading guilty to count 5, aggravated assault and misdemeanor punishable by up to a year. And then assault by strangulation, a felony punishable by up to 10 years. Now, there's this added count 7 that I mentioned earlier, and that's called a home invasion in the second degree. A home invasion in the second degree is a felony punishable by up to 5 years and or up to $3,000. So far, I'm sorry.
Your Honor, I think that's the third is 5 years, a second.
Well,
15 years is the second, Your Honor.
that's what I said.
You said 5. That's what I heard.
No, 5,000, 15 years or $5,000. It's okay. If I said it wrong and Mr. Carnes heard it wrong, I will make sure everybody understands. It's a felony punishable by up to 15 years. And I said 5. If I did, it's wrong. It's $3,000. So we got it. Thank you very much, Mr. Carnes. No matter what, we now know we've got it correct. Is that what you understood you were doing today?
Yes, sir.
All right, good. Now, I have here this pretrial agreement. It's 2 pages long. And when I look at it, this is given to me by the attorneys, on page 2 here, it looks like that's your signature. Is that your signature?
Yes, sir.
Now, before you put your signature on that piece of paper, did you go over the terms that are on page 1? And did you talk to your attorney to ask her questions, things like that?
Yes, Your Honor.
Was she able to answer your questions?
Yes,
And when she answered them, did she answer them in a way you understood them?
sir.
All right. Also, did you talk to you about the evidence against you, your options, going to trial, things like that?
Yeah.
And possible tactics? Did she talk about those?
Yeah.
And are you satisfied thus far with her representation?
Yes, sir.
All right, great. Now, if you enter a plea of guilty today, you're not going to have a trial. Does that make sense?
Yes.
I'm holding up the second piece of paper that your attorney provided to me. At the top, it says advice of rights, and at the bottom, it appears to have your signature. Once again, is that your signature?
Yes, sir.
Now, did you read through these rights before you signed them?
Yes, sir.
And did you understand the words and rights that you read? And even more importantly, to understand that if you enter a plea of guilty today to the 3 charges that we discussed earlier, you will be forever waiving these rights as they apply to this particular case.
Yes, Your Honor.
Of course, that's only if I accept the plea. Now, there are things that help courts establish appropriate sentences. One of them is called the Michigan Sentencing Guidelines. Has your attorney talked to you about guidelines?
Yes, sir.
These guidelines are given to the courts by the legislature to hopefully help us pick. That's right. To the courts, yeah, by the legislature to help courts establish a fair, reasonable, proportionate sentence. I want to highlight for you that they help establish only for felonies, the minimum end. Right, so if it's, I'm just gonna use a random number, if it's guides me to a range of say 10 to 20 months, then I can pick somewhere in between there. Does that make sense? And that's for the minimum. Now I want to highlight for you the guidelines are not mandatory. While the courts must use them, we need not follow them. We are required to use them, and we generally do. We're generally within the guidelines. Also, the sentencing is up to the court. Has Ms. Firavento or anyone led you to believe what the sentence will be yet? They've talked, Ms. Firavento has probably done a good job trying to give you an idea.
Yes.
Hey, here's what the guidelines are. Here's generally what Judge Elmore in my perception would do or might do. That's fully appropriate, but has anyone promised you exactly what I would do?
No, sir.
All right, great. Knowing all that, do you still wish to enter the pleas of guilty that we discussed earlier?
Yes, Your Honor.
Before we do that, you need to talk to Ms. Firavento at all, or? Yes?
We did meet again this morning before coming on the record, Your Honor, and we met again last week.
Yeah. Mr. Carnes keeps leaning over.
Your
It's
Honor,
a-
we misstated. It's actually a no contest plea due to intoxication at the time of the offense. I believe Ms. Firavento has the incident report copies of that.
All right, Mr. Oswald, that's going to change a little bit of what I said, not a lot. I just need to cover a few more points. You can either enter a plea of not guilty, guilty, or no contest. The no contest plea has the same impact as a guilty plea, meaning you don't have a trial, you waive all those rights we talked about earlier. But instead of requiring you to tell me what happened, to satisfy the elements of proof. I'm gonna look at something else. Now, here's some key things about a no contest plea. Again, besides it having the same impact as a guilty plea, you can't come back and challenge what's on there. Okay? So what'll often happen, I'm sorry, you understand, yes?
Yes, sir.
Thank you. I just gotta make sure Nancy gets the word. Yeah, let's say you come back for sentencing. It happens on occasion. The defendant who pleads no contest will come back and say at sentencing, well, I didn't really mean it. I don't really agree with what the report says. You understand you don't get to do that. Okay, what's in there is what's in there. It's the other option is to testify and say you did it. Now, there's a couple instances in which I can take it. One is for potential civil liability, which means, let's say you broke somebody's jaw, they could sue you for that. The other one is intoxication, like you just don't remember it. Or the third is the interest of justice. So I'm told here it's number 2 of those, but it probably could be all 3. Understand?
Yes, sir.
Okay. So now I'm going to go back. I'm going to ask you how you plead to those counts 5, 6, and added count 7. I'm going to remind you that I anticipate your answer to be no contest. That's not me telling you what to say. That's just me who sat up here for a long while. And I know that because you people watch way too much TV and movies, they'll automatically say guilty. So I anticipate it to be no contest, but it can be whichever one you choose.
Okay.
As to counts 5, 6, and added count 7, how do you plead?
No.
Now, before the court can enter or accept that no contest plea, do I have a report? And let's go ahead and have it stamped.
Yes, Your Honor. Thank you. And I have shown this to the prosecutor ahead of time.
All right, thank you.
Thank you.
Now, since the prosecutor has the burden of proof, we're going to call this plaintiff our People's Exhibit. I now have that handed to me. People's proposed exhibit number 1 for identification is a City of Cadillac Police Department Incident Report number 26-464 with a date of February 21st, which is consistent with the date on the felony information. And it deals with the jurisdiction of the City of Cadillac and Western County. And it consists of initially 4 pages. Then attached to that is a separate report. Actually, let's do it this way. Nancy, would you please give me a second exhibit sticker number? This is the Michigan State Police Department report. Since it's a different agency, I'll just have it marked as a separate exhibit. Thank you. This is Michigan State Police Department Incident Report 71-518-26, and it is 5 pages. Mr. Carnes, are you asking the court to accept People's Exhibits 1 and 2?
Yes, Your Honor.
Any objection, Ms. Fioravento?
No objection, Your Honor.
People's Exhibits 1 and 2 are hereby admitted. One moment. Again, the court makes a finding that the dates and jurisdictional elements are satisfied from the exhibits. All right, thank you. Mr. Carnes, do you believe that the interests of justice do not require by the factual basis and the acceptance of the no contest plea is appropriate?
Yes, Your Honor.
Do you believe that exhibits 1 and 2 have evidence that satisfy the elements to support the convictions for counts 5, 6, and added count 7?
Yes, Your
And are you aware of any of the promises, threats, inducements?
Honor. No, Your Honor.
I believe that I have complied with Bishop Rule 6.302.
Yes, Your Honor.
Ms. Fiorvento, do you agree with all 4 of those statements?
Yes, Your Honor.
Thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the information contained in People's Exhibits 1 and 2 satisfy the factual elements. The court also finds that they're in the interest of justice, as well as the level of intoxication, which is referenced in there, and even the potential of civil liability, particular to the defendant LMF is in addition, would support a potential civil liability. The court finds the defendant's pleas today are made freely, knowingly, and voluntarily. Therefore, the court finds the defendant guilty of count 5, count 6, and added count 7. Mr. Oswald, we will be back here in about 4 to 5 weeks. Between now and then, and by the way, we do sentencings every Monday morning in this court. Between now and then, an agent from the Michigan Department of Corrections is going to prepare what's called a pre-sentence investigation report. One of these reports must be prepared anytime someone is convicted of a felony in a state court here in Michigan. This report will include a description of the offense, a description of the pretrial agreement, any statement information you make or provide, as well as information about any prior criminal history you do have or don't have, how you performed on bond or probation before, if that's appropriate. You will also include statements from any victim in the case. You'll have the right to make statements. There are 3 steps that involve you in the preparation of this report. Number 1, you're going to get a packet, and that has just been handed by the clerk to Deputy Longstreet. He'll give it to you when you leave here, and you're going to open it up, follow the instructions, and turn it in. Number 2, you'll be subject to an interview with an agent in that office, and you have the right to have your attorney present during the time of that interview. And number 3, Ms. Fiorvento is going to come speak with you about the report prior to coming back to sentencing. Each side has the right to come to this court and make objections, request corrections, tell us if there's an error, because we want to make sure that it's complete and appropriately accurate before the court bases a sentence on it. The report will also include a score into the guidelines. Please keep in mind that it's strictly just a suggestion. It will also include a recommendation as to the guidelines. Keep in mind also that it is strictly a recommendation, as the court alone will determine the sentence. Any questions, sir?
No, sir.
Thank you. Mr. Carnes, anything further on behalf of the people?
No, Your Honor.
Ms. Fiorvento?
Your Honor, we may address bond pending sentencing.
Sure. That way, wait, hold on. Mr. Carnes says no objection, so yes.
Thank you, and I did discuss with Mr. Carnes before coming to the record today. We would respect the request if we were able to secure a rehabilitative facility between now and sentencing, if the court would allow release to that rehab for treatment between now and then. It's my understanding my client has never been to a rehab facility before.
Does he have any prior convictions of any kind?
The problem we're running into, Your Honor, is that the rehabs need a release date, and we were not able to give them an actual release date at this point. We would respect the request if he could secure a date in the next 3 weeks, and then we could just adjourn out the sentencing to let him complete the program.
What is the potential issue for which he needs rehabilitation?
Alcohol, Your Honor.
How old is he?
21. 19, I do apologize.
All right. If I were you, I'm sorry, I'm going to say right now, I'm not going to grant anything. But if you do, and you want to bring it to the court with Mr. Carnes as a stip, you know the typical language would have to be added, but I also want to know more about his history. How long has he been using? Who has allowed him to use? For instance, does he have parents who just aren't there? I mean, I want to know a little bit more about Mr. Oswald than what I've got here so far, before I go modifying the file. Yes, sir.
Just to clarify, I'm not willing to stiff. I score him at 36 to 71 months based largely on the offense variables, not his
I'm-
prior.
yeah,
So I'm gonna oppose it, but
Okay, all right, then,
defense is welcome to bring it.
then the answer is then you need to bring further information on a motion. Am I likely? I'm gonna look at what the guidelines are, and the likelihood is probably not high. All right, so anyways, thank you very much. We are adjourned.
Hey, Karen.
Mr. Carnes, or sorry, whoever, your exhibits, please.